Hello aspirants, I am Karthikeyan from Inkar IAS Academy. Today we are going to discuss about the 21st December current affairs. The topic is it is for historians to dig for telltale remains not bigots. This topic comes under our GS2 government policies and intervention for development in various sections and issues are arising out of their design and implementation. The first of all, why it is in the news. Normally, digging an historic site is done an archaeologist and historians in search of lost civilization or an ancient city or some signs of mythological events, but nowhere in the world. In the modern age, is an excavation done underneath a place of worship of the religion to find remain a place of worship to another religion, while digging in such a historical fact is a secular act. What is done using internationally recognized scientific methods, digging to establish the presence of a place of worship of one region in a place of worship for the another region is clearly a non-secular act. Therefore, it is absolutely puzzling why the former Chief Justice of India, D.Y. Chandrachud, found nothing objectionable or illegal in a survey in a place of worship of a particular religion by another religious group. In his oral observation, the former CJS said in 2022, the Places of Worship Special Power Act. Actually, it is enacted in the Parliament in the year 1991 in the background of a strident movement of Ram Janmabhoomi supporters, which heightened the communal tension in Ayodhya and many other parts of the northern India. So, the government of the day apprehended the imminent outbreak of the violence in different parts of the country due to the raising of the claim over the places of worship of a particular minority community. This acts for the conversion of the places of worship any religion community into a place of worship of a different religion community. Declares that the religion character of a place worship exists in the 15th day of August 1947 shall continue to be the same as it existed on that day. So, this is a powerful statement underscore the responsibility of the historians to investigate, interpret the past based of the evidence free from bias or prejudice. It suggests the uncovering historical truth should be a meticulously scholarly endeavor rather than one driven a bigotry agendas. The Place of Worship Special Power Act, first of all, the act is an Indian law enacted to preserve the religious character of the place of worship. It is existed August 15, 1947. The act was passed by the Parliament of India with the intent of promoting secularism and also maintaining the harmony among different religious communities. Below are the key provisions and details of this act. First of all, what is the key feature of this act? There is a status quo of 1947. First of all, the act prohibits the conversion of any place of worship into a place of worship of a different religion. It is mandated the religion character of a place of worship must remain the same as it was on August 15, 1947. And second thing, the prohibition of the legal claims. The act was filing a new lawsuits or legal proceedings challenging the religious character of a place of worship as of cut-off date. Ongoing cases regarding the same are also to be dismissed. And the third thing, the exemption for the Ayodhya. The act specially exempts the Ram Janmabhoomi Babri Masjid dispute from its purview, allowing legal proceeding related to the issue to continue. Because the penalty for the violation was any act or the contravention of the provision of this act is deemed a criminal offense and also punishable by imprisonment, and also it will be penalized for the fine. And the protector of religious harmony, that is the act was induced, that is to prevent the communal tension and also prevent the harmony, and also there is a protect of secular fabric of India by ensuring that disputes over the religious places were minimized, and also there is a constitutional basis somewhat provision, that's a supporting act. This is advocates argue the act is crucial for maintaining the peace and harmony in a diverse country like India. It prevents the misuse of the historical grievance and also foment the communal disharmony. The criticism of the act was that some groups have argued that act freezes historical injustices and also prevent the rightful claims over the disputed sites. Others claims it undermines the right to judicial recourse, the judicial scrutiny, the final thing in recent year, the constitutionality of the act has been challenged in a court with debates over whether it infringes over religious and cultural rights. Would you? That's why it can be scrutinized by the judiciary. So, the first of all, we must clearly note down the key grounds of the constitutional challenge. That first of all, it is the violation of the fundamental rights. That is a petitioner argued that the act violates the Article 25, that is a freedom of religion, and also the Article 26, that is a freedom of managed religious affair, by freezing the status that religious places on August 15, 1947, thereby curtailing the right of the religious community to reclaim or restore the place of the worship. The restriction on filing legal claims is seen an infringement of the right of the judicial recourse under the Article 32. There is a constitutional remedies under Article 32. And also there is a unequal treatment. This is a critics allege that the act violates Article 14, that is a equality before law, by treating the Ram Janmabhoomi must dispute differently from other similar dispute as it specifically examples the Ayodhya from its purview. This is the major debate today. And also there is a freezing historical wrongs, that is a opponent claim the act that perpetuates the historical injustices by preventing the community from the seeking redress for the declaration of the conversion of this place under the article worship before 1947. And also there is a legislature overreach. It is argued that the act interferes with the judicial power by barring courts from adjudicating disputes over the religious character and also the place of the worship. Though, so it is belongs to the legislative overreach. And also there is some support for this act. There is a support of this act constitutionally. First of all, the secularism and also the harmony, that is a proponent assert for the act upholds that India's secular fabric as a ensuring that preamble Article 25 and 28 by preserving the religious character of the place of worship and also the preventing communal violence and tension. And also there is a reasonable restriction. The government defend the act as a reasonable restriction under the Article 25 of 1, that is emphasizing the prevention of public order and also the communal harmony justifies a limitation on the certain religious rights. And also there is a historical content. Finally, the act seeks to draw a line under the communal conflicts of the past and also prevent the recurrence by maintaining the status quo. The key development of the legal challenges, first of all, there is a Supreme Court observation. There is a hearings on petition challenge the act. The Supreme Court has observed that the legislation serves the promote the secularisms and also protect the communal harmony. But in September 2022, the court admitted petition challenging the act and issued notice to the union government to respond this kind of claims. And also there is a government defense. The union government in its response has defended the act as a measure to prevent the unnecessary communal disputes and also maintaining the peace. And finally, the Ram Janmabhoomi verdict 2019, the Supreme Court judgment in the Ayodhya case, while addressing the exemption granted to the Ram Janmabhoomi side, that is under the act that upheld the broader principles of the secularism and the need of the preserve communal harmony. And finally, the argument presented in the court was that is a petition that highlight the act undermines the principle of the justice by preventing the redressal of the historical grievances. And also there is a respondent, that is Union of India, argued that reopening historical disputes could lead to the communal violence and also unrest. So highlight the act role in upholding the secularism and also constitutional morality. So the Supreme Court rules against the act could potentially open the floodgates for disputes over places of the worship across the country, destabilizing communal harmony, and also conversely, if the act is upheld, it will reinforce the idea that the past cannot be litigated endlessly and the preserving local order takes precedence. Thank you so much.